Welcome back to Supreme Myths. I'm Eric Siegel. We are recording this at 1 o'clock on Wednesday, on January 20th, and President Biden has just been sworn into office. And I just have to say, in a personal note, I've been doing this podcast for a long time, about 8 months now. I'm not going to hide it. To me, this is a happy day, and I'm looking forward from here. And it's an especially happy day for me because I finally get to talk to someone in person who I've never met, but who I've certainly associated with on social media and other places, but who I really respect, and I'm so glad is here. And that's Keith Whittington, who is the William Nelson Cromwell Professor of Politics at Princeton. He is not a law professor, but he can be a law professor. He has written too many books, too many articles, too many essays to go through. He is an expert on originalism, on impeachment, on free speech, and I would say overall judicial politics. And of course, judicial politics is my great interest, so I'm just so happy that Keith is here. His essays and op-eds have appeared in the New York Times, the Washington Post, the Atlantic, and he is a blogger for the Volokh Conspiracy. Keith, thank you so much for being here.
Oh, thanks for having me. I really appreciate it.
Oh, it's my pleasure. So we're going to do this podcast, I think, in two kind of segments. First, we're going to talk current events, and then we are certainly going to talk about originalism, because you kind of wrote the book on new originalism, and everyone knows I'm a critic of new originalism,
Sure.
so I'm really, really happy to do that. But first, so I assume, is it a foregone conclusion, do you think, that the Senate is going to have a conviction trial on impeachment for Donald Trump?
It certainly looks like it. I think it's imaginable that the Democrats might decide that it's too much of a distraction and they'd rather not pursue it. But that doesn't seem to be their current instinct. Instead, they are increasingly seem to be talking not just about the possibility of delaying the trial by several months, which at one point seemed to be in the air, but instead trying to multitask and do impeachment part of the time in the Senate, and then also have the Senate do regular legislative business during other parts of the day. Certainly possible for the Senate to do that. But it is this awkward moment of having passed an impeachment of a former president hanging over the launch of a new presidency. That's inevitably going to suck up an awful lot of the airtime and the energy that otherwise would have been very much focused on the Biden administration.
If I don't know what your politics are, but if you were a Democrat leader in the Senate or the House, or if you were President Biden, do you think they should go forward with an impeachment trial?
I think it makes sense to go forward with an impeachment trial. I think there are multiple things you're trying to accomplish with an impeachment generally, and a presidential impeachment, I think, in particular. Obviously, one thing that's usually front and center is the possibility of removing the officer. That's not at stake anymore for Trump. But I don't think that makes the impeachment irrelevant. An impeachment is still an opportunity to try to expose what happened. And try to set the record straight as much as possible. Undoubtedly, there'll be hearings and commissions also trying to do that. But I think the impeachment trial can be a useful venue for trying to do that. It's an opportunity to condemn a particular individual for the actions they've committed. And I think in this context, they may well be very important to do that and to get members of Congress on the record of doing that and try to establish some expectations in the future. It's important, I think, to send a signal to future government officials about how intolerable Congress thinks this kind of behavior is. And of course, there's still the opportunity of disqualifying Trump from future office. And I don't know how significant of a motivation that is or ought to be for the Senate. But there is an important symbolic aspect, I think, to the impeachment even now. And I think it's probably worth pursuing, despite the downsides of it occupying attention and energy.
So there are some people out there who you and I respect, I think, Bruce Ackerman of Yale and a few others, who have suggested that it's not illegal, that one cannot be impeached once one leaves office. I don't agree with that. You don't agree with that. Why don't you tell who's ever listening why that's wrong?
Yeah, I think there's a variety of arguments as to why that's wrong. There's obviously the intuitive position, right? Because we emphasize so much that impeachments are about removing an officer. The intuitive position then is obviously then what we ought to be focusing on are incumbent government officials. That's mostly what we have focused on throughout American history. And so it's very natural for people to think in those terms. And really, the first time I even came across and started thinking about the possibility of impeachment of former officials, I was initially very skeptical of it for the kind of normal reasons everybody else would be, until I started looking at it more closely and really trying to think it through. And then really came to the conclusion that I think that's perfectly valid. I think there are potentially two separate issues worth separating to some degree, which is can the House impeach a former official? That's not what's at stake here. Trump has already been impeached. And so, of course, we have this awkwardness that we tend to talk about impeachment as both as being the thing that the House does when they level allegations, but also we talk about the entire process as being an impeachment. But what's really at stake for Trump now is can you have an impeachment trial of an existing set of impeachment charges of a former president, or does the Senate lose jurisdiction of that trial as a consequence of the officer, in this case, having his term expired, but in other cases, an officer resigning, for example, which we've had over the course of American history. Just on a pure textual basis, there's nothing in the constitutional text that suggests that that's necessarily the case. The Constitution tells us what happens to incumbent officials when they're convicted, which is they're automatically removed, and then they may also have the further punishment imposed of being disqualified. But the Constitution doesn't specify that you can only impeach incumbent officials. And it says the Senate has the authority to try all impeachments. There's no question that the House impeachment was a valid impeachment under even the narrowest conceptions of what that means, in which case it seems quite logical to think then the Senate has the power to try that impeachment that's now been lodged and put in their court. But in addition, if we think about sort of the core of the impeachment power as is textually granted to Congress, both the House and the Senate, what's given to the House is the sole power to impeach. And so then the question is, well, what did the framers have in mind when they said you have the power to impeach? What is that power they're handing off? And might it include the ability to impeach former officials? And in that context, it's striking that both in the British history and in American state history prior to the adoption of the Constitution in 1787, impeaching former officers was not only well known, but commonplace. The two impeachments that occurred in the English Parliament in the century prior to the drafting of the US Constitution both involved former officials. And they referenced those impeachments in the context of drafting the convention. So for them, it would have been obvious that, of course, you have the power to impeach former officials because that's in fact what Parliament does most of the time. Likewise, the state constitutions explicitly allowed impeachment of former officials. And that was part and parcel of how they understood the impeachment power more generally. And of course, like I said, we've had some experience with trying to do this as well, most notably in the case of Secretary of War William Belknap during the Grant administration. He was impeached by the House and then he resigned. And then the Senate went to trial. And of course, he made the motion, his attorneys made the motion that the Senate didn't have jurisdiction because he was a former officer. And the Senate, by majority vote, set aside that motion and proceeded to trial. Belknap was not convicted. It's very hard to get the 2/3 vote, and these kinds of doubts can affect that. They affected it in his case as well. I expect they will affect it in Trump's case. I really think in Trump's context, what we'll see is the motion to dismiss will be defeated, but it will be very hard to convict the president. It's hard to convict a president regardless, but I think this adds an additional wrinkle that many Republican senators will want to latch hold of as a reason not to convict.
So I agree with everything you just said, even though a lot of it was about the 18th century or 17th century. I still agree with it. I want to take a slight detour.
There are good prudential reasons for thinking we ought to be able to impeach former presidents too, and other former officials. But and we can talk about those too. But yeah. I do think there's other rationales besides just the one that they're familiar with. But it is striking that just from a pure textualist, originalist perspective, I think that the case here is actually pretty straightforward.
I actually think from an originalist, textualist, and what we'll call it for sake of argument, living constitutionalist or pragmatic perspective. Yeah. We'll get into that later. I think it's an easy case. So I want to take a slight detour for a minute.
Sure.
So Bruce, for listeners who don't know, and many won't, Bruce Ackerman is a extraordinarily famous constitutional law professor at Yale. He wrote a book about constitutional moments that did, within legal academia, change a lot of debate. Still does, about constitutional law. He's an important figure. I know him a little bit. He's a thoughtful man. Yet he writes this op-ed in the Washington Post, uh, not about this issue directly, about Section 3 of the 14th Amendment
Right.
and how Trump engaged in insurrection, and we should use that. I don't want to get into that yet. Here's my question. I do wonder if the desire to be, and you know, Bruce Ackerman is as famous as he's ever going to be, and he's a famous guy. Yet he so quickly concluded that it would be illegal to have a trial in the Senate after Trump leaves office. And you read that op-ed and you think, well, he just wants to make all he can of Section 3 of the 14th, and which, by the way, I agree with on the merits. But leaving that aside, I think social media has done this, or op-eds. I mean, it used to be write an op-ed in the New York Times, and without social media, only people who got the New York Times to them would read it. Now you write an op-ed in the Washington Post, New York Times, and it's amazing the reach. I have an intuition that it's kind of watered down the scholarly efforts of a lot of people, including maybe myself, maybe you, maybe others. I don't know. But I'm trying to find a reason why Bruce Ackerman would take such a position that is clearly at odds with the text, the history of the Constitution. Do you have a theory about that relationship?
Well, I'm very reluctant to think that that problem is true of Bruce. He's a very careful scholar,
Yeah.
tends to not move very quickly,
Right.
Takes his time to develop these
Right.
ideas. And he's particularly concerned with this history of the 14th Amendment and the Reconstruction period and its significance, and did a fair amount of work on thinking about impeachments in particular in the context of the Clinton impeachment. So it's not a topic that's unfamiliar to him more generally. I don't know the full logic of his argument as to why he thinks it's problematic to pursue President Trump through the impeachment process and why he necessarily would prefer the 14th
Keith, I'm sorry to
Amendment.
interrupt, but it wasn't that he said it was problematic. That would have been fair.
Yeah. Yeah.
He
yeah,
said
yeah.
it can't be done. And it's hard to imagine
Yeah.
Bruce, being a careful scholar that he is, writing
Right.
a law review article in that way. Like, he wouldn't do that.
No, well, that's true. Of course, that's partially so. So I think there is a social media issue, and I actually do want to get back to that because I think it's important about thinking about scholarship more generally and how we do these things in public. But there's also an op-ed writing feature of this, which is not trivial. So I've written a few op-eds over time. I try to talk about things I actually have some expertise in public when the opportunities present themselves. And unfortunately, impeachment has created some of those opportunities, given that it's one of the things I spend a lot of time studying. But it's the nature of op-ed writing is that you are writing for a broad audience. You're trying to make bold and clear points. You have very little space to do it in. Editors really don't like qualifications. And so all the little wrinkles that you want to put in as an academic to qualify, to clarify, to cabin what you're saying, the force of that kind of publication just drives that stuff out. And so there's always, I think, some tension then between even as good scholars, how we can communicate to the public through the kind of venues that are available to us, whether it's in the small number of characters on Twitter or whether it's through even 900 words in an op-ed, and the kind of thing you'd want to do in your scholarship. I think it's always a little bit unfair to judge people by their op-eds as opposed to their scholarship because they're just different formats and they have different demands on what you can reasonably do. I do think we are in not only a social media age that's significant for affecting scholarship and scholarly discourse, but the polarized nature of our time probably contributes to this as well. But one feature of social media in particular in this regard, and here I want to use it very broadly to include the blogosphere, for example, that really predated social media as such, is that it does allow an awful lot of people to speak directly to a larger audience without gatekeepers. And so you don't have to sell it to the Washington Post and convince them that this is worth publishing and this is the best thing to publish relative to the hundreds of other things that they're being attributed to them that they might want to publish. You don't have to work with their editors and sort of manage their gatekeeping process. You can just post it right away. And so there's an immediacy to it. There's an audience that allows you. But it also, I think, both allows and incentivizes hot takes in a way that is in real conflict with the normal scholarly process. And and our media sort of reinforces that, right? I mean, the kind of people that the media wants to pull in to talk about even things like impeachments are not necessarily people with any actual expertise on these things. And so the choices that get made and the kinds of people who get attention, both in the social media arena and even in the established mainstream media, traditional media, um, is not necessarily conducive to the kind of slow, careful thought that academics
Sure,
hopefully
sure,
prefer,
right,
and also are put a lot more emphasis and give a lot more rewards to extreme, sometimes counterintuitive, often fantastical takes, because that's what people want to hear. So one thing I've been struck by over the course of the Trump years in general, and I don't know to what degree this is entirely new or if I'm just being exposed to it more, is the extent to which there's a lot of wish casting that goes on in legal commentary around these things, where we think it would be really nice if the law or the Constitution worked in a particular way because it would achieve certain things we want to achieve at the moment, and so we just say it does. And you can find very established scholars who are willing to lean into that in ways that I find quite distressing. Um,
yeah.
I get that people have unconventional arguments, and I'm happy to engage in those arguments. And of course, social media is often not the right venue for engaging in it. But there often does seem to be in a lot of incentives to encourage people to uh, uh, let's say, develop theories that they normally wouldn't be trying to offer if we were simply talking about conveying them in a more scholarly arena as opposed to the more public arena.
Yeah, so I think that's all really interesting, and I agree with. And someone who blogs, writes op-eds, has a podcast, which I don't know, I'm not sure I'm going to continue or not. We'll see. But a short story. While and people are going to yell at me for bringing up Posner again because I bring him up a lot. But while he was a judge, uh, Judge Posner and I wrote an op-ed about Justice Scalia and his theocratic impulse.
Right.
And, because he was still a judge, obviously, we wrote it carefully. And I think we made a compelling argument about Scalia's theocracy, but we had to deal with the Smith case. So for those who don't know,
Sure.
the Smith case was a case where Justice Scalia wrote an opinion that made free exercise claims much harder. That's all we need to say for now. A kind of surprising opinion for Justice Scalia. He had his personal reasons for doing it.
Mm-hmm.
Anyway, to make this op-ed work, we had to deal with that because we were accusing him of a lot of other things. And we did. And the New York Times took it. And by the time they were done with it, we just couldn't fit that part of it in. And it made us, and so it made the op-ed much weaker than it would have been. And it made us more vulnerable to, for, Ed Whelan, who was a joke, and we block each other and all that. But actually, Ed Whelan just wrote a review of a book review that I wrote, and he admitted in his review that he hadn't read the book I was reviewing, which is he did all of that for the National Review. So I reviewed a book.
Right.
He criticized my review while admitting that he hadn't read the book. But anyway,
Right.
And that op-ed in the New York Times was a fairly big deal, not because of me, of course, but because of Posner and criticizing Scalia.
Sure.
But it wasn't that strong. And it started off strong, and it was frustrating.
Right.
So I get it. However,
Yeah, that's a challenge of these things. In one way, that's I think one of the advantages of podcasts. Actually, you have more time to sort of lay out arguments. You're not doing it in writing, and so other kinds of mistakes creep in,
Yes.
And difficulties associated with that kind of form. But I just taught a class for the last couple of years on constitutional problems during the Trump administration, because there's all these kind of weird, exotic constitutional issues that have come up during this administration. And one of the nice things about it, and so it's a much more sort of contemporaneous, focused on current events kind of class than what I would normally do. But one of the really nice things about it to help make it possible to do a class like that is just how much sophisticated constitutional commentary there is in the public sphere that is responsive to the moment, that is accessible to a broader public, that's relatively brief, that you can give to students to do in a reading for a day, for example. I don't think I could have done that class, certainly not in the same kind of way, 10 years ago.
Yeah.
Just because those kinds of analyses were not always there. And so there are lots of downsides to the sort of generating that stuff very quickly, putting it in this kind of form, et cetera. But there's also just tremendous upsides. And there are really good examples of this kind of discourse that really does elevate the conversation in public and brings the genuine expertise of scholars to bear on immediate problems, and tries to make it accessible to a broader public. And that happens in podcasts, it happens in blogs. It probably doesn't happen so much on Twitter, but it's
Actually,
but there are opportunities to do those
no.
things. And it's really good.
So I've had my Twitter nightmares, although for some reason for the last month they've all come from my left, which I don't really understand, since I consider myself a very progressive, person. But living.
I was just called a lefty on Twitter yesterday by a guy with an awful lot of followers.
Right.
So, weird things happen on
right.
Twitter.
Well, I was called worse names than you can imagine by people on my left. But I do want to say, that for people like me at non-elite places where I just, if you're Princeton, Harvard, Yale, Stanford, you have a built-in platform. There are social media has given those of us in not those places.
Yeah.
And I also want to mention about blogging that, I've written 45 law review articles and probably 500 people have read them. I don't know, in total, cumulatively.
Sure.
And I've had it's not like the Vala conspiracy, which has a bigger reach, but I write for Dorf on Law, and I'll have 2,000 people read a blog post, at least click on it. I assume they read of mine.
Right.
Right. And I can't tell you many people. Chris Sprigman of NYU tweeted about, 6 months ago, that he's not a con law person. Chris started off as a different, but he tried to teach con law, and then he decided it's all made up. This is his word, shit. And then I wrote a whole blog post about how to teach con law when we know it's just justices making shit up. You don't have to agree or disagree yet, but the point is, I had so many con law professors write me and say, I've been wrestling with this, and it's hard, and it felt so good, and I think one blog post. Now, I'm where I'm going to be. I'm a chair professor. I'm 63. I'm not going. But to have your peers give you that feedback, is really good, and it's very hard to do that in law review articles. It is.
No, absolutely. It is one of the nice things about. So it's true about scholarly articles. I find it true about books. Right, you spend a tremendous amount of time trying to write a book, years potentially. You go through the process of getting out there, and then you have no idea what happens to it. Right, it just sort of disappears out into the void. And you're sort of fortunate if you sort of every once in a while get little morsels of, hey, somebody actually read the thing, and they have a reaction. So one of the really wonderful things about social media, but also about blog posts, and op-eds, and other things, is one, you get a massive reach relative to what academics often do. A lot more people are exposed to and read that stuff than what would be true of the average scholarly article, for example. And the reaction is often much more immediate, where you can actually see the fact that people are reading it and they're responding to it. Sometimes not responding to it in the way you would hope, but
most of the time.
But you are at least feeling like there's an audience that you're reaching to some degree with those kinds of things. And in that sense, it is a nice and somewhat rewarding difference than the scholarly process. And I find that true of doing things like, I publish a bunch of stuff in Lawfare, for example.
Lawfare, by the way, excuse me, Keith, for those listening, Lawfare is a really, really serious and important blog that people should read.
Right, produced by the Heritage Foundation, primarily does sort of national security issues, but in law and legal issues associated with national security, but has really expanded out during the Trump years of doing sort of larger separation of powers kinds of problems broadly. And so I've published several things in them, and one of the really lovely things about doing that is you write something and then 2 days later it's available for readers, right? As opposed to, and it's one of the nice things about law reviews, frankly, relative to the peer review process of political science journals. You can write something long and scholarly, send it off to law reviews, and in just a few weeks, it's accepted someplace.
Really?
And in a few
not
months,
anymore, Keith. No, that's not true anymore. So,
that's still pretty true, right? Whereas in peer review journals, I've had things that have taken years and years and years before they get accepted, let alone ever appear in print in a peer review.
Well, this will be our first disagreement. We'll have more later. Keith, the law review process is as painful and awful as it could possibly be, because from sending it in to a real law review article I'm talking about, not an online. Well, I think online law review articles are real. What I meant is a print law review article. It's at least a year, at least, from trust me on this, from submission to, unless it's like a special symposium.
From submission to publication appearing in print.
It's at least a year.
Yeah. No, the gap to actually get the thing in print is pretty long. But I am like the mouse pushing the lever to get the food, right? So I just appreciate the immediate reaction of, hey, you'll take this and you will publish it.
Right.
It's like, and for me, that's sort of massive success, because then I move forward and think about other things, right? And so then I'm really annoyed by, oh, now I have to edit the thing, and eventually it'll show up in public and other people will see it.
Right.
But relative to the peer review process, that where you write something and it might take years before the thing is even accepted for publication, the speed of the law review process of getting accepted for publication is just extraordinarily faster. And so there's all kinds of frustrations, admittedly, with that process, and there's all kinds of frustrations with getting it to print. But compared to other scholarly journals and how they work, the law review world is a very nice complement to that system in how quickly it can move things along.
Yeah.
Even though it has lots of downsides.
I gotta say, I don't like that take. For one thing, having second.
You should publish in some peer review journals on occasion, and then you might appreciate.
Well, I did. I have published in Constitutional Commentary on numerous occasions, and that is a peer review journal.
Yeah, not quite the same, but yeah.
No, but I was going to say about.
I mean, they're in part because they're working in the law world space, and so I think they're trying to also move a little more.
All right.
Quickly.
Well, you're forcing me to tell a story then.
I know.
You are forcing me to tell my favorite law review story. My 10-year article was called Justice Scalia, Critical Legal Studies, and the Rule of Law. And what this article basically said was that Justice Scalia and critical legal studies, a far left, some would call Marxist, but had much more in common than they would think.
Right.
And my target in that was a guy named Mark Tushnet, who actually has been my mentor for my career. And I was pretty critical of Mark, and comparing him to critical legal studies. Sure. Comparing him to Scalia is not something he would like.
Appreciate that. Exactly.
George Washington, and so we're stuck with students. So George Washington takes it, and this is back in the day when no email. I mean, it was all by phone.
No, right. It's all by mail.
And so I had to then call the 10 or 15 elite law reviews above George Washington to ask them to take it. Right. So I left a message for the Michigan Law Review, and the student calls me back and says, "Where was it accepted?" And I said, "George Washington, and here's my deadline." And he went, "Oh."
Right.
And I said, "What do you mean, oh?" And he said, "Well, might have been better if it had been sent to Georgetown."
Right.
And at the time, Tushnet was at Georgetown. And I said, "Well, I have an idea. Why don't you ask Tushnet his opinion about this?" At the time, I didn't know him. We don't know each other. He did give me comments on this article, pretty critical. But overall, I think he thought it was solid. But it's about him. So and it's critical of him. So call him and ask him. No, we don't do that. Right. I said, "What do you mean you don't do that?" He said, "We don't call professors. They do now, but they didn't then." And I said, "So you care what the editors of the Georgetown Law Journal think, but you don't care what their professor thinks? You don't have that problem. We have that problem."
No, it is a weird world of how law reviews work and how the decisions get made as to what to publish. And I frankly, from the outside, just the process of submission is strange, right? Yes. And so I had no idea what I was doing the first few times I submitted the law. So oddly, it took more than once, right, before I figured it out. But I didn't know what I was doing when I first, and in part because the web didn't exist in the same form to explain to me how it works, right? And so I submitted completely off cycle, for example, and I couldn't understand why everyone was rejecting this thing. It's like, oh, well, it turns out because you're submitting like completely wrong time and everything's full. Right. Which of course is not how the normal academic publication process works at all. And so it's got all kinds of downsides and oddities to it. And I have had my frustrations with it. But I really, one thing I like about our current scholarly publishing environment, despite all the downsides of various components of it, is I do like the diversity, at least for people like you and me who are working in this particular space, where everything from books to peer review journals to law reviews to blogs all exist as venues to try to get stuff out. and you can make different points in different ones.
I
They
agree.
appeal to different kind of audiences.
Yep.
It's a different process,
Yep.
and so I love the sort of options in that sense of thinking, well, look, that this thing I'm working on probably belongs in a book, and I should be aiming for that. And other things I'm doing really belong in a blog post, and I should be aiming for that. And the fact that you can do all those things from where I sit now is just terrific, and very different from how I felt when I was starting my career.
Agreed. Agreed. So we got sidetracked there. My fault about social
Yeah, I
media.
know we haven't talked about impeachment very much.
Yeah, it's my bad. But that's interesting, and I do think some of the people listening to this are academics at non-elite schools, and I think we all feel a little bit liberated by the different amount. At least, back in 1991, effectively was law review's books or nothing.
Right.
Now it's much different. I do want to talk about Section 3 of the 14th Amendment, but I want to do it quickly because I do want to get to originalism. Okay. So why don't you tell everyone what Section 3 of the 14th Amendment is and whether you think it is something that the Congress should use?
So Section 3 of the 14th Amendment, of course, is one of the Reconstruction Amendments. It actually has several parts. We tend to mostly pay attention to the first section because the first section has the most relevance to most jurisprudence and constitutional law, and it lays out the Equal Protection Clause, the Due Process Clause, and the like. Section 3 is one of the sections of the 14th Amendment we mostly ignore, in part because it does seem very antiquated and less relevant to day-to-day life, and it specifically disqualifies from future office anyone who has previously held office and taken an oath to defend the Constitution and then subsequently engaged in insurrection. And then Congress can waive that disqualification by a 2/3 vote. Obviously, this had lots of significance in the immediate context of the Civil War and the immediate aftermath of the Civil War. And so the potential application was quite obvious to them, and the potential need to exclude people who might not be found guilty in treason trials, but nonetheless, they thought many of the Reconstruction Republicans thought were inappropriate to ever hold public office again. This was designed to deal with them. The interesting question is, does it help us with anything else since then? And the answer is mostly sort of been thought to be not much. And so it's really been sort of isolated as a sort of historical oddity that was relevant to the Civil War context, but not so relevant to subsequent context. It's been used a little bit since then, but not very much. And so, it's one of the weird features of the Trump administration that's made us talk about all kinds of obscure features of the Constitution. Right. And Section 3 of the 14th Amendment is one of them.
He has been great for constitutional people.
I don't know if it's good or bad necessarily, right? We spend our time now talking about self-pardons, right, and insurrections, right, and all kinds of things.
Well, so if evidence comes out that he really did know about, encourage, expect, right, and not do anything about the attack on the Capitol, and I think that will come out. I have no idea, but I think it will. The advantage of using Section 3 of the 14th Amendment over an impeachment trial in the Senate is that it takes majority vote in both houses, not 2/3. And I think that's a big deal. I also think maybe, I'm very cautious about this. I'm not usually a cautious person, you know that, but I am cautious about this.
Yeah.
Maybe labeling him an insurrectionist is a good idea for the future. I don't know.
Yeah. I don't know either. It's judging how people respond to Trump, and I've never been very good at. Because I seem not to appreciate the charms that others see in him, and so I continue to find it puzzling the extent to which he clearly has a charismatic influence on large numbers of the public and the electorate. In ways I just constantly find surprising. And so I don't know what it takes to really put a serious dent in that charismatic appeal. And I don't know if labeling him an insurrectionist would necessarily do it. It's entirely possible it creates a backlash such that people say, oh, well, you're trying to keep out my visionary leader, and this is just an elitist purge, and we ought to be even more supportive of this populist candidate. So I think there are some real risks associated just on that dimension. But lay that aside. So one of the complications of Section 3 is it has this sort of bold statement that if you've engaged in insurrection under these conditions, you're disqualified from future office holding. And it has a specific mechanism about how you can relieve people of the disqualification. But it doesn't say anything about how do you enforce the disqualification.
Right.
It doesn't say anything about how do we know whether or not somebody has been disqualified. It doesn't even tell us what insurrection is and
Right.
how we go about defining it. So it's all these very open-ended uncertainties about the actual mechanics of applying Section 3, which is part of what's complicated its use over time. Although the fact we don't have very many insurrections helps. So um, and I now, as people are trying to resuscitate Section 3 for this purpose, I've seen several different kinds of theories being offered as to how it might be relevant. And I'm much more skeptical than some than of others. And so some people have suggested that Trump could actually be put on trial in an ordinary court on
Oh,
charges of
really? I haven't
insurrection,
heard
and
that.
if he's found guilty. Well, in fact, it was suggested the other day, in part, not necessarily even for a criminal trial, but instead Congress created a specific statute designed to enforce Section 3, in which you'd have a judicial hearing to determine whether or not you fell within the confines of insurrection. I actually don't mind that as a process, right? Because my concern about Section 3 and the way people talk about it in general is how much due process do you get in being able to defend yourself against this kind of charge? How specific is the charge itself going to be? Is there going to be some kind of mechanism to arbitrate these kinds of claims? Or are we just going to say by majority vote, Congress can ban people from holding future office? And if we think that's true, I think that's a really slippery slope that once we start going down, is going to have all kinds of really dire problems about how democracy works in general. Because I do not imagine that's going to be limited to the Donald Trumps of the world. It's going to we're going to wind up using it across a much wider range of government officials. But this kind of process where you say, okay, the disqualification might take place, but only after a serious and fair and fairly rigorous adjudicatory process, I'm much more open to that idea. In general, I've been sort of skeptical about Section 3 as opposed to thinking about the impeachment power, because the impeachment power also includes the ability to disqualify.
Right.
And part of what I like about the impeachment power is precisely that it gives you a trial in the Senate, and that's a more political process than what you get in front of a court, and there are downsides and upsides to that. And of course, the impeachment power includes a much wider range of potential offenses. And so you don't have to worry quite so much about how exactly to define insurrection, as opposed to a wider set of things that we think are a
Right.
kind of political
Fair
misconduct
enough.
that ought to get you disqualified from holding future office. So I like both the sort of breadth of high crimes and misdemeanors compared to insurrection, and I like the fact that it has an adjudicatory process, even though it's the Senate to do it. And some of the versions of Section 3, I think, don't have that. But there are other versions that I find a little more appealing and I think are more plausible, although I'm not at all confident that, in fact, you'd find yourself with the kind of factual grounding to really support an insurrection claim that would lead a court to condemn the president as having participated in insurrection.
Yeah. So on Twitter,
Again, it seems like one of these things where people sort of hope about what would happen,
right,
and rather than actually,
right, it could backfire.
having a hard-headed reason for actually thinking that's how it's going to play out. And so a lot of people could find themselves very disappointed that you put Trump into a judicial process and lo and behold, he's acquitted.
Right.
Next thing you know, he's screaming about total vindication, which may not be what you're looking for.
Yeah. On Twitter yesterday, Jed Sugarman of Fordham, who I really respect, he really thought this is a terrible idea. It'll lead to progressives and liberals being. But my response to that, maybe. I mean, certainly maybe. But we had a violent attack break-in of the Capitol. I mean, if that's not insurrection, then I really don't know what insurrection is. But I don't want to comment.
So I don't mind the people who actually stormed the Capitol. I think we certainly should be throwing the book at them, and we should be thinking about things like seditious conspiracies, in thinking about how they ought to be criminally prosecuted. And I would like to see prosecutors seriously examining, does this meet the factual requirements of something like that in some of these cases. I'm just much more skeptical about can you actually develop the evidence to think that somebody like the president or some of the other politicians, for example, actually meet that kind of standard. And I'm really skeptical of the idea of, well, what we really ought to do is ask the majority of Congress to decide what they think counts as insurrection, because it's not hard to imagine people saying, well, have you said nice things about the Portland rioters trying to break into the federal courthouse? And if you did, you too were providing aid and comfort to
Fair
insurrectionists,
enough.
because that's just as much of an insurrectionist kind of activity by some lights as what happened in the Capitol. I don't think nearly as severe and all kinds of other things I would distinguish them, but it's very easy to imagine those things going
And that was
forward,
Jed.
right? In
That was
ways,
Jed's concern, and it's a fair one.
yeah.
All right.
And even sort of rioting and more generally, right? So even laying aside the federal courthouse thing in Portland, just generally the summer riots, right?
Right.
I think it's not hard to imagine how a majority of a Congress might be constructed such that they would think that all kinds of politicians who, in the view of the majority, was lending aid and comfort to rioters ought to be disqualified from future office. And that just seems like a door we don't want to open.
Fair enough. Fair enough.
I'm also very reluctant to expel people like Cruz and
Oh,
Hawley
me
from the
too.
legislature for similar kinds of
Me too.
reasons, right?
Me too.
Well, at least there's a very high bar of expelling, right? It takes
Yes.
two-thirds vote.
Yes.
And so I value the high bar.
Yes.
But similarly, I think there's just a lot of again wishing that bad things can happen to your political enemies that will allow people to set aside all the general concerns they would have in any other kind of circumstance,
Right.
or if they were thinking about it in more cool detachment from any particular episode, where they might say, well, maybe it's not such a great idea to be expelling senators for making motions that are allowed by the rules of the Senate.
Well, I agree. As much as I despise Cruz and Hawley, I agree with that.
Yeah.
100%. And there's that whole cliche: bad cases, hard cases make bad law, and I agree with that.
Right.
I would push back a little bit on. I think there's a lot about Trump that can be a one-out situation, and maybe this one, but I want to move on. So I need to set the stage. I need to. So give me a minute here. I need to set the stage for you and originalism and me.
Sure.
So most people who are listening to this or watching this probably know that although the idea of using the original meaning of the Constitution is as old as the Constitution, and I concede that in my work, it became a school of thought, a separate school of thought, in the late 60s, 70s, when a law professor named Raoul Berger and Robert Bork, who at the time was at Yale, came up with this notion that the war in court and Berger was a liberal. He's a Democrat. He's a liberal Democrat.
Yeah.
Came up with this idea, which I, by the way, agree with, but that's a different conversation, that the war in court was going crazy and out of its mind,
Right.
and the only way to rein in the war in court was through relying on what they called the original intent of the drafters. Today, we mostly call it original meaning. We can get into that in a minute. But
Sure.
so that all happens in the 60s and 70s. And just for the record, for people out there, I am on record in a book, 10 blog posts, and 5 articles. I agree with Bork and Berger. I'm actually more originalist than any liberal you're going to find. But I agree with them because I believe their work was more about what we call deference than originalism.
Yeah.
To them, it was a tool to get judges to do less. And I want to make that clear. Originalism was a tool for judges to do less. So that goes on through the 70s and the 80s. And then we get 12 years of Ronald Reagan and George Bush judges. And in comes Keith Whittington. And in comes Randy Barnett. And in comes Larry Solomon. Is that fair? You three?
Sure.
And you come up with those two law professors, and you're not a law professor, but with this idea of new originals. And you are your name will be forever associated until you can't, if you can't, which I think you should, with the new originalism with Randy and Larry. So let's just start off by, was this a group effort? Was this an individual effort? Because the three of you really did change the conversation, at least in academic circles.
So I think it's fair that we did a lot. We weren't the only ones working in these areas or talking about it at the time, but I do think the three of us in particular attach this label of new originalism, and I think we're doing a lot of work surrounding a common set of ideas that did help move the agenda on thinking about originalism in constitutional theory. and I think we all came to it separately and for somewhat different reasons. So I started working on originalism in my doctoral dissertation at Yale in the early 90s. And Ackerman was one of my professors there. Um, uh, I arrived at Yale as a grad student, not too long after the Bork hearings and sort of the fights that occurred during the Reagan administration over these things. So I was intrigued by originalism as a theory generally. But as I started working on it and thinking about it more as part of thinking about potential dissertation project, I was increasingly frustrated by what I saw in the theory. It seemed to be very under theorized, not well worked out, had all kinds of problems with it, wasn't particularly responsive to the various criticisms that have been made of it. So I became increasingly interested about, is it possible to construct a better version of an originalist theory, one that actually engages the scholarly arguments and can stand up to scholarly scrutiny to a greater degree. And I came to that partially because I had these interests in originalism and whatnot, but partially because I was in grad school primarily as a political theorist and was sort of interested in democratic theory generally. And there are lots of overlaps between thinking about the specific context of originalism and that. It's also in that context I first became interested in impeachments, because the other half of my dissertation was not on originalism, but instead was on a kind of living constitutionalism. How has the Constitution developed over time, primarily outside the court system? And impeachment seemed to be one of these interesting vehicles or places where Congress was really on its own to grapple with constitutional meaning, where the court wasn't going to be looking over their shoulder and modifying it. So oddly, I'm still talking about the same things I was talking
Right.
about
Full
in the
circle. We
dissertation.
call that full circle.
Full circle, right? So you never fully escape your old research projects, and although impeachment's one in particular. So I actually thought at the time, right, the impeachments would never be relevant again because this was like this historical thing that I thought was sort of interesting, but that'll never happen. So sort of arcane and irrelevant, as any good scholar should be, and the originalism I really thought was sort of dead in the water by the early mid '90s. It didn't seem to be taken seriously in academia. Politically, it didn't seem to be gaining a lot of traction. I really thought proudly that nothing I was doing in the dissertation would resonate with anyone anywhere. So I was sort of pleasantly surprised that it did. And in part, I think
Well, Keith, I'm
separately,
sorry.
Randy.
Let's cut to the
Yeah,
chase. You
yeah, yeah,
you
yeah.
changed the Burger Bork kind of
Yes.
deferential originalism to something else. Tell people listening, watching what you did. You changed it.
Well, so my emphasis, I think, was on several things. So partially trying to think about how do you separate it from the specific arguments about intentions that people had, and how to think about intentions, I think, in a more sophisticated way that I think bleeds over into public meaning. I think they're pretty connected, but a lot of people draw a sharp line and really want to focus on public meaning of the text instead. I do
Pause
think
for
that,
1 second.
yeah,
So that distinction between original public meaning and original intention
right,
isn't the best. There's other evidence, but isn't a
right.
substantially important element of original meaning the intentions of the people who wrote the words?
Sure. No, I think they are. I mean, I think the part of the emphasis on, I mean,
Richard
so
Kay,
look,
if
there
you're
are
out
several
there, that
things
was
that,
for you. Sorry, Richard Kay, that was for you. Go ahead.
yeah, yeah,
Yeah,
yeah. No, right. No, they're totally fair. And I like Kay's work a lot. I
yeah,
mean, Kay was one of the people who I think was taking a very sophisticated approach to thinking about
yeah.
originalism when I started writing, and heavily influenced the kind of way I wound up approaching originalism in general. So I'm glad you had a shout out to Kay because he is actually quite important
Yeah.
for my own intellectual development. Um, uh, so right, intentions I think are relevant to thinking about what the public meaning is, which is one reason why I think that they are connected in ways that other people would draw a sharper line between them. I think part of the emphasis, though, of why people would want to focus their attention on meaning in particular, instead of intent, is one, you have this struggle of what do you do about sort of so-called secret intentions, right? So to what degree should we really be focused on what was inside people's heads as opposed to what they were saying in public? And the move toward public meaning really emphasizes what is the case you made, what's the claims you made, what's the rule you laid down in public that other people could
Sure.
access, not necessarily what intentions people had in their head. It also, I think, emphasizes in useful ways sort of a distinction that sometimes people make between sort of expected applications and what the rule is that's being designed, right? So a lot of intentions that people have about adopting a piece of text are very focused on particular cases they have in front of them and they want to deal with, and expectations they will have about what the implications of adopting this text is going to be down the road. Um, and part of what the emphasis on public meaning wants to highlight is, look, what you've adopted are not those expectations about future applications or the particular cases people have in mind. What you're adopting is a rule. And the rule might, in fact, disappoint their expectations about how this is gonna play out down the
Can we
road.
pause on that point for a second?
Yeah.
So the original public meaning of the 14th Amendment as it applies to gender discrimination. I want to talk about this with you. I really do.
Yeah.
So what Larry Solomon has said, what
Right.
Ilya Somin has said, and what Elon Werman has said, three
Right.
originalists, is that we don't care that they expected that women wouldn't have equal rights. And they
Right.
didn't. I mean, of course, women in 1868 didn't have equal rights.
Yeah.
They couldn't vote. They were married. They were property of their husbands and so on.
Right.
But
did not think they were making sweeping changes in the legal landscape.
Well, it's more than that,
Yeah.
right? I mean, you're the expert on the 14th
Right.
Amendment. They discussed this.
I'm not.
Oh, okay. So, well,
Yeah. I'm not an expert on the 14th Amendment, right? I mean, so it is true that there are others who know the 14th Amendment far better than I do, but
you know a lot about it.
But we'll see how far we can
Okay,
explore
fair
this
enough.
before I sort of feel like I've exceeded my grasp on
Some
on
of the objections to the Equal Protection
Yeah.
Clause and Privileges and Immunities Clause
Right.
was and giving blacks the right to vote, giving blacks the rights. The objection was, oh no, then we'll give women rights. And everybody said, don't worry about it. We're not going to give women rights. All right. So how do we go from, if someone is an original public meaning originalist, how do we go from absolute certainty that the original public meaning of the 14th Amendment in 1868 did not mean equal rights to originalists saying it does mean equal rights? How do we do that?
Yeah, so I certainly think that to the extent that it seems like everybody had a common set of understandings about what the implications of adopting a rule were going to be, you should be pretty cautious and hesitant if you think you've come to a different conclusion than the people who are drafting it, right? And because one thing that should lead you to do is, one, just think that your reasoning is wrong about why you think some implications go out one way rather than the other way. But the other thing it should, I think, lead you to be very cautious about is the possibility that you're misunderstanding the rule they adopted, and that there's a logic by which they're getting the implications that they think are going to follow from it. And that logic really implies that they were adopting a somewhat different rule than you initially thought. It's a little bit like the late impeachment thing, right? Where for you, it might be completely intuitive. You read this text and you think, oh, well, of course, X, Y, and Z follows from it. And then you start exploring it more deeply and you realize, oh, well, it turns out it doesn't so easily follow. It goes in a different direction. And sometimes you don't know that until you start looking pretty carefully, right? And so, and that's true for both us, and it was also true for them, right? When they were drafting in the first place, right? For them, it may be intuitive to say, well, of course, it's not going to have anything to do with women. And you really, I think, ought to interrogate that to see, okay, well, look, let's really think through the principle you've adopted here, the rule you've laid down, and think that through. And some of it may be that they just got it wrong. It could be.
What do you mean? Hold on. What do you mean got it?
Yeah.
Explain got it wrong.
They got it wrong in the sense that they are wrong about the implications that follow from the principle they've adopted.
Okay, hold on. I want to go slowly here because, sorry.
Yeah.
They got it. They got the implications wrong from the rule they adopted. Now, what Solomon and what Solomon says about that, and so is Chris Green, who's a friend of mine at Ole Miss, and originals. They all say they thought women's skills were limited, and women couldn't do certain things. And Solomon, by the way, calls that a view about facts. Not even facts, but a view about. Okay.
Right.
So I wish we had another hour, but we
which is a different implication. I think it's also possible that the thing they got wrong is the understanding of the fact situation.
Yes.
Right? And so it could be they're making certain assumptions about what the implications are going to be, and what drives them to those assumptions is a certain understanding of the facts, and it turns out those are wrong, or it turns out they change over time, such that the rule now has different effects than it previously had because our circumstances are quite different.
Okay, wait, pause.
I think that's totally consistent with thinking the rule itself is fixed and is determined by the meaning of it at the time it was adopted.
But this is the question I've been wanting to ask you for 10 years. Everything,
We'll see how badly I screw it up.
everything you just said. I wish we could replay
Right.
it. I wish I could roll the tape
Sure.
back. I wish Matt could roll the tape
You
back.
will be able to replay
But
it.
everything you just said,
Right.
a living constitutionalist would say. No, no,
I
hold on.
think
Let
a
me
lot
finish.
of
Let me finish.
Yeah.
They may have gotten the facts wrong. They may not have been aware
Right.
of the implications. The facts
Right.
might even change. And Solomon says changes
Right.
in facts can lead
Right.
judges to disregard original public meaning. He says that. He absolutely says that.
I'd have to look at how he says it because that seems surprising. But yeah, go ahead.
I've quoted him in 5 different arguments.
No, probably, yeah, I just would want to see what the context is he's saying because I'm trying to figure out, do I disagree with him or am I just not understanding what he's saying? But anyway,
but here, so what I'm saying about the 14th Amendment and women, I think we can say about virtually every constitutional law issue, which is this.
Yeah.
The people, hold on, let me strike that. A lot of issues we have today, they never thought about. Drone strikes on American citizens in Yemen, they didn't think about. And
absolutely,
all kinds
of course.
But when they thought about issues like gender equality, which they did,
Right.
if we're allowed to discard the expectations we know they had because of a change in either they were wrong or times have changed, that's what Justice Brennan would say. That's what Larry Tribe would say. That's what Mike Dorf would say. They would say we go back and we look at the meaning, the original meaning, and that's a factor.
Yeah.
But if things change, we shouldn't be bound by those meanings today.
No, but note, I did not say the original meaning is a factor. I said the original meaning is fixed, and the question is what the implications that follow from the original meaning is. Part of where I think Brennan would go a different direction is he does not think the original meaning matters necessarily.
I don't think so.
We can discard the original meaning and replace it with something we think is better.
Well, that's what Solomon. What Solomon does. That's what they do.
So that is not, so it depends on what you think about the meaning is, right? So if you think that the expected applications are part and parcel of the meaning that they adopted in that text, then yeah, that's for sure part of what the so-called new originalists would be changing. And there certainly are originalists who think that that the new originalists have made exactly that mistake, and that the new originalists are no better than the living constitutionalists because they have made that move.
Steve Smith at San Diego has made that argument strongly. I think
Right. So Steve's not happy about these kind of moves. He thinks they're wrong as they get the Constitution wrong. They're wrong about the nature of the theory and how we ought to understand it. And I understand those disagreements. I'm on the other side of it, which means that I think there's actually is a lot of commonality between originalist theory, as I understand it, and what a lot of living constitutionalists would say and do. The actual how do you cash that out and work through the logic, there are going to be differences. But I think there's actually is a lot of common ground. I think, though, there are also some pretty important differences. They're still there. I think much less commonly now than was true early on. So I just taught a seminar on originalism, for example, and my starting point really was to give the students material from the progressive period through the 1960s, right? And one thing that's really striking is the extent to which people just say, yeah, they had some ideas, but we ought to just implement a constitution that satisfies us, then we think it would have a great set of principles and rights. People just don't talk that way anymore, right? And so that's mostly off the table, so part of why I think there's so much common ground then between how I think about originalism and how a lot of living constitutionalists think about their theories is because not only have I moved from where Bork was on originalism, but the living constitutionalists have abandoned a lot of the more extreme claims that they were commonly making through much of the 20th century. And there's still, I think, important differences. There's things to argue about, et cetera. I just do think there's been a lot of convergence among theorists and sort of how we think about these things and talk about them. And so there's still small differences. Those differences are still important. They give plenty of fodder to argue about. But I do think that an awful lot of scholars have sort of converged toward a more common position.
Well, I will take that because that's been my scholarly kind of ambition for the last few years.
As Elena Kagan said, we're all originalists now.
Yeah.
Right?
Oh,
so
no,
it's in this sense, right?
No. What she said.
I just had to poke you with it.
Well, no, don't spread that rumor. She said that after she said, sometimes the Constitution lays down clear rules, and when it does, we should follow them. President has to be 35.
Yeah.
Sometimes they lay down general principles. Then we have to follow those. She's balking all the way. And Balkan's...
Yeah. And So Balkan, I think, is pretty good on the theory.
Yeah.
Actually, I think Balkan's lousy at the practice.
Good on
so
the
all
theory.
my
Well,
disagreements,
that's
a
interesting.
lot of my disagreements with Jack are about how what the history looks like and how we play it out, but and how do we interpret particular texts.
Right.
On the theory side, I think Jack's actually quite good.
Yeah. So
I learn a lot from him, and I agree with him
right.
about a lot of stuff.
Jack was my first podcast person. And what I told him, and what I told him in person 5 years ago, was the book Living Originalism that he wrote.
Yeah.
I mean, for lay people, that title is very strange. Well, for law professors, that title is very strange. Is one of the most rich, accurate descriptions of how constitutional law is made in this country. It's not just the Supreme Court. It's movements, it's Congress, it's people. What's wrong about that book is the word originalism, because there's nothing really originalist about that book. We're running out of time, so I need to ask
certainly
you.
some originalists who would agree with that. But yeah,
Say again?
Yeah. Certainly a lot of originalists would agree about that,
Yeah.
about that complaint about Jack. I agree, though. It's a terrific book and well worth reading.
So, all right. So I want to thank you for this. And I want to end this, not yet, but with a big question. Jacob Ten Broeck in 1939. 1939.
Yep.
I'm terrible at math. What's that? 20 years, 30, well before the war in court. Writes a series. I'm sorry?
Before I was born.
Before I was born. Yeah. Well, before I was, I'm older than you, but before I was born also. He writes a series of 5 law review articles in the California Law Review in 1939. And I admit it's the height of the legal realist movement. I admit that. But
absolutely,
where he says from the very beginning, the Supreme Court has not cared about text, has not cared about history. They do what they think is best and right, pretty much all things considered. And he gives proof of that. And it's an amazing work for 1939. As a descriptive matter, not a normative matter. And I've had trouble in reading you and getting you pinned down on this.
Well, it's because I wear multiple hats, and so I am all over the place.
Well, we all. That wasn't a criticism.
Well, I'm a political scientist, so so some of what I do tries to talk about those descriptive issues and how I think the court actually behaves. And then I also have this interest in normative theory and what I think the court ought to be doing.
Sure.
And never the twain shall meet.
Yeah, me too. You and me both, because I'm a clear error Alexander Hamilton guy. So we've never had that Supreme Court. I do want to ask you, Keith, in all seriousness, my first book, Supreme Myths, went through, a dozen heavy doctrinal areas where I showed, the court changes its mind over time, all the time, in virtually every area of litigated constitutional law, and 2, in almost every doctrinal strain, there is incoherence that makes the blood boil.
Right.
Because what they're really doing in the big cases, the cases we care about, is what they think best. And as Judge Posner described in How Judges Think, when you have a case that raises your blood and is abortion, affirmative action, campaign finance, the big issue, you have an intuition of how you want the case to come out, and then you see if the law allows it, and if it's Judge Posner, it might not allow it, because when he was a judge, bound by it, but the Supreme Court's not bound by anything. Are you a legal realist when it comes to a descriptive account of the Supreme Court? Pure description.
Yeah. No, I think I'm pretty realist about the court in that sense. I don't know if I'd go as far as more extreme versions of that, which exist within political science as well, where there are those who say it's all just policy preferences all the way down. And I tend to resist that within political science debates. I think the law does matter. It shapes what the justices are doing. But in particular, when we talk about this sort of subset of cases that are most divisive, most polarizing, where the law is least clear, the policy preference is most intense, there's a lot of just policy that drives those decisions. And I do think policy in that sense also rests on the back of there's a set of value commitments that underlie that that help guide sort of why the justices have these policy preferences. There's a set of larger understandings about the constitutional order that helps set up those disputes. But in the context of the specific debates in the specific cases, there's a lot of policymaking going on. I think judges, one reason why I think there's never going to be a very good match between the normative stuff and the empirical stuff, is the judges are, to some degree, a kind of policymaker. And moreover, they're collective institutions, and they're politically responsive and politically situated. And so, no matter how beautiful my normative theory is, they've got their own things they're doing, and what they're doing is not constitutional theory. And so there's going to be a gap there, right? And I think if you're going to realistically think about the empirics of the court, that's part of what's going on. So I just had a book to come out, one of these books I worked on for a decade, Repugnant Laws on the History of Judicial Review and the Supreme Court of Acts of Congress across
It's a great
all of
book,
American
by the way.
history.
It's a great book.
Thank you. I appreciate that. And, one feature of that is very much how is the court situated within the broader political environment, and how are decisions being shaped and influenced by lots of political assumptions that are going into those decisions. And that's true, particularly of the high profile cases, right? The lower profile cases are often much more technical. The temperature is cooled politically. And you see the judges, I think, behaving a little differently, but especially on these high profile things, the things that are most contested, the things we all care the most about, politics is pretty close to the surface.
So when you say, and we're about done, but when you say they're policymakers, and when you say the politics, I think you said, are close to the surface and all of that, right. I'm wondering, I'm asking you a personal question. This is a totally selfish, personal question. And I ask it on behalf of people like Mark Tushnet, Jeremy Waldron, all the legal realists of the 1930s, Carl Llewellyn, Holmes to some degree.
Right.
Do you understand my frustration that I have a hard time getting academics, not the American, when I talk to non-lawyers, they get this. But when I talk to academics, when I say, in the cases the justices care about, the law plays at most a minimal role compared to their evaluation of what would be the consequences of their decision, which is not that different from you saying they have a policy-making role. But when you say that, it sounds like it's okay. What I'm saying is, why can't we unanimously agree that the Supreme Court, as a descriptive matter, since Dred Scott, has been an institution that their preferences will override the law in cases they care about, which is why Justice Ginsburg, an American hero, who deserves to be an American hero for her prior Supreme Court work, but voted liberal every time. There's almost no cases she didn't vote liberal, and there are almost no cases Alito and Thomas don't vote conservative. Why can't we just admit that? Like, why can't you just say to me, Thomas is a Republican judge who votes Republican. Ginsburg was a Democrat judge who voted Democrat 99% of the time. Why is that hard to say?
Well, so just as a footnote, I would say well before Dred Scott.
Okay, fine. All right, fine.
From the very start of the court, this was true, and it's still true.
Sorry for that rant, by the way.
No, that's totally reasonable. And I do think you're right. I mean, law professors, I think, have a vested interest in resisting this.
I wrote that and got in trouble. I wrote that in my book, and I got in big trouble for it.
Yeah. Right. The political scientists just don't. Although it's striking the extent to which I've talked to law professors who don't do common law, and they're like, that common law stuff, man, that's just all made up stuff. And not like the real law that I do over here in contracts or something. So common law gets that kind of rap, I think, even among law professors. It's but the struggle professionally for a lawyer, for a law professor, is to try to make legal sense of what the court's doing and what the arguments are here. You can't just walk into court as a litigator, even in one of these cases, and say, look, justices, this is the Republican position on this, act accordingly. Right? That's not how it works.
Well, that's not how it works. But in fact, whether it's affirmative action, let's talk about, Fisher versus Texas, or whether it's abortion, or whether it's Citizens United, or whether it's the death penalty currently happening. In fact, you could walk into court. You're not going to you will not change Thomas's or Ginsburg's votes, no matter what you say in those cases. You won't.
No, you're not. Although I think it's to some degree reductive to refer to them simply as Republican and Democratic positions on that. And moreover, I think it's also
no, I would say conservative and liberal. That's what I'd say.
Yeah, conservative and liberal, I think, captures it more appropriately, and to some degree, it's also wrong in the sense that one thing we've observed quite a lot over the last 4 years is that in the political realm, terms like Republican and let alone conservative
Agreed.
can be highly malleable as to what
Right.
what falls
Yeah,
in those
Keith,
categories.
to be clear,
Right?
I am not an
Yeah.
attitudinalist. I'm not a political science
Yeah.
attitudinalist. I am it's values all the way down, not politics all the way down.
Yeah, and of course, I think the attitudinalists are sort of so the attitude. Just to be clear for the audience, right? So there's a theory of judicial decision making that arises in the 1950s and 1960s that is particularly focused on the U.S. Supreme Court and particularly interested in arguing that individual justices vote on the basis of their underlying preferences in the cases that come in front of them, and those preferences are reduced to their attitudes. What has always been a little obscure about the attitudinalist, it's very useful for descriptive empirical work and political science. You can do a lot with it. It has its limitations too. I've been a critic in various ways, but one thing that's sort of obscure about attitudinalism is what exactly the nature of the attitudes are. And so if you say that justice is a conservative justice and therefore they'll vote in particular kinds of fairly predictable ways, what is the thing you're capturing in saying they're a conservative justice? And it's a bundle of things, I think. To some degree, it may be some partisan preferences, it may be some policy preferences, it's a set of values, it's a set of understandings about the Constitution and the rules associated with it. And so and some of those things are going to be more in the fore of the decision making in certain kinds of cases and other kind of cases. And so I think it's kind of messy once you get under the surface of what we mean when we say attitudinalism.
Yet, and I'm going to say this, then give you the last word, then say goodbye.
Yeah.
Yet, Sotomayor and Ginsburg reliably vote a certain way. Thomas and Alito reliably vote a certain way. And then we had the Souters, the Blackmans, the Whites, the Stevenses, the O'Connors, the Kennedys, who reliably we weren't sure. And that's because Alito and Thomas are really conservative people. And Ginsburg and Sotomayor are really liberal people. And Stevens, Blackman, White, Souter, and Kennedy were more moderate people. The point I want to make in that, Keith, is
no, I think that's fair.
Their moderation or their liberalism or their conservatism, it's about that, not about pre-existing legal material in the high-profile cases we're talking about. You can tell me why I'm wrong in that.
There's an important, I was going to say there's an important qualification here in that, it's a subset of the cases the justices deal with in which one can say that Sotomayor and Thomas are going to reliably be in opposite ends of the case, right? There's an awful lot of decisions where they're on the same side of these cases, although fewer than there used to be.
No, that's true, but they do that on purpose. You know that. I mean, they can't take 90 abortion cases. Then the gig would be up.
I think there's some purpose in the sense of probably some strategic decision making on the court's part to not take 90 abortion cases, but also it's on purpose in the sense that there's a whole range of cases that in fact rise to the level of the court, and maybe more that should rise to the level of the court hearing them, that just don't trigger these particular partisan polarizing features of how the judges think, right? And so there's a tremendous number of cases, including some constitutional cases, where the judges are going to be more likely to be on the same page rather than be in opposite corners. So I don't think we would want to totally overstate the extent to which the court is polarized all the time on everything.
Right.
And once you've said that, then it opens the door to asking, well, why are they united on all these other things? And I think part of the answer is because of legal considerations, right? They're much more prominent in a lot of these other cases than they tend to be in some of these high-profile, more polarizing cases, the abortion cases, for example.
So I feel like you and I could talk about this topic forever, like I talk about whether Michael Jordan is better than LeBron James or whether Tiger Woods is better than Jack Nicklaus. He is. Or whether Godfather 1 is better than Godfather 2. Or in Posner's words, whether a margarita is better than a Cosmopolitan. I feel like what we're really saying is we prefer one to the other, which is all of con law. Anyway, Keith, I really appreciate you doing this. I've been wanting to meet you for a long time like this, and especially today. I think we can both agree it's a new day.
Yes.
Okay. When people hear this, it'll be not a new day anymore. But I really appreciate you coming on, and I could talk to you for hours, but then the audience would go away. So
Yeah, I really appreciate it.
no, it was all my pleasure, and thank you so much.